Absolutely. So I'm going to turn this one back to James since he presented on that topic. And there was a question that there was an employer that said that they were going to put employees who do not get vaccinated due to religious reasons or a disability on unpaid leave. Do you think that that's legally permissible for them to do that?
Well, it's a good question, right? I mean, the question, first of all, is going to be is there, first of all, there has to be some analysis there for disabilities or religious discrimination. If it's just an employee objecting based on their own beliefs, it would appear to me that there's no prohibition on an employer disciplining an employee from following an otherwise enforceable policy or practice that the employer is requiring. However, if an employee asserts that they have a disability or requires some type of religious exemption, then before that employee is put on leave or disciplined or terminated, there's going to have to be that analysis as to whether or not they can be accommodated or whether or not it's a direct threat issue.
Okay, and then another one, and Lakeisha, you can speak up on this one too if you'd like. It said that Montana recently passed a law forbidding vaccine mandates. Any thoughts on whether it will be preempted by Biden's actions?
I don't know about preemption. I know that that the courts, when dealing with, and this will really be in my research anyways, the first time that the federal government has imposed a mandatory vaccine policy with regards to private organizations. Generally, where we have seen those come from is the states. And a lot of the case law challenging mandatory vaccines, either in certain workplaces or in educational, have come from the states, and the cases upholding those have pointed to the police powers of the state to pass those. Now, the police powers of the state to ban vaccine mandates is going to create a really interesting question to go to the Supreme Court, I think. And the answer to that, I think, is fairly uncertain. There was an article in the Boston Globe which sort of went through the case law and how old the vaccine mandate case law really is, and how since that time, there's just been a number of cases that have found that people should have autonomy over their healthcare choices and those types of things, including Roe v. Wade, ironically enough. And so this Supreme Court could address that and determine whether or not individuals have that right, or if that's a power reserved for the state to protect. You have anything, Lakeisha, you want to add to that?
Well, the only thing that I wanted to add is just that very question was one of the ones that was proposed to the Department of Labor. And my understanding was that she gave a very, the chief attorney there, a very diplomatic response, something to the effect of they will partner with the local OSHA related entity to try and partner with that state to determine how to enforce that. So, I guess the answer is only time will tell. Like you, James, I don't know if there's really a preemption issue, but certainly, how this all plays out, I think it's going to depend.
Classic lawyer answer, right?
I mean, I think that's just the place that we're in, James. As I was looking at some of the questions, the one thing that I know I talk to my clients about all the time is that, yes, I know that the fact patterns are fact patterns that you probably haven't seen before, right? It's definitely testing your knowledge as to what the ADA provides, what reasonable accommodations you have to provide, and all these other things. But I think you continue to do, at least as a starting place, everything that you used to do before we had COVID. The interactive processes, implementing your policies and procedures, all the rules regarding what you have to do regarding reasonable accommodations, all those things still apply. And so I think if we start there as a starting place, I think that's the best place you can be in, because there's just so many things that they're unknown, right? Sorry, I'm looking at some of these questions that are coming up regarding vaccination, and clearly there are going to be a number of issues that come up. And I think the other thing, and this is speaking from the world that I live in, a lot of this becomes industry focused, right? That for certain industries, this whole mask mandate poses an issue because, for example, if you're in the restaurant world, there's already a labor shortage, right? And if you impose this, vaccination requirement, how do you address that issue? And so someone I saw in the chat asked about, what about just requiring employees who've not been vaccinated to wear a mask? And I think that's where most companies have been. But unfortunately, if you've read the entire plan that Biden rolled out, that's not only about requesting or demanding that vaccination happen in the workplace, he is gung-ho, if you will, about ensuring that overall, whether it's in the federal sector, the private sector, in schools, that there is a big push to just get as close to 100% vaccination as possible.
Okay, great. Another question was, a local foundation is asking for vaccination rates for staff when considering a grant application, in the hopes of encouraging vaccination. In light of statutes prohibiting dissemination of private medical information, should employers ask consent to reveal the vaccination rate? Do we think that's a problem? Obviously, if you had 100% rate would reveal that all staff were vaccinated, and does that include, invoke some type of invasion of privacy or ADA violation?
Boy, that sounds like a really good bar exam question. My initial thought is no, because you're not revealing the names of who is and who is not vaccinated. However, you're right. I mean, if you say 100%, we're at 100% vaccination, then you're indicating that everybody there is, it would be safe to assume. These are all going to be interesting questions that come up that we've never addressed before. And so I think we are going to see a flurry of litigation. Something that occurred to me when I was researching the religious stuff is, for a long time, we've had this divide between what is a personal and political view and what is a religious view. But in today's day and age, it seems like people's political views sometimes are more dearly held than religious views and permeate more aspects of their lifetime. And I'm wondering if we are due for some additional cases, potentially where individuals are claiming their political views are religious views, and whether or not the court system as it's currently built would be inclined to extend religious viewpoint discrimination and religious practice discrimination to include political views, given some of these issues. I don't know how that would come out. It's just me thinking about it, but it seems like that all of this could sort of come to a crescendo. And I think you're highlighting one of those issues too that could also be well litigated. Is that a violation of someone's privacy interests?
Okay, great.
Can I address one thing that I see in the chat, or one of the questions that we didn't talk about? And there's been a couple questions about incentives related to vaccines, or kind of a related question about, I see one here about additional premiums if you don't receive the vaccine. And just, let me say this, and James, if your practice is different, certainly chime in. Let me say this as a general proposition. I'm not a benefits attorney, and I don't profess to be. But as a general rule, what I would say is, if you have questions, if you're advising employers, for example, or you have a worker that's raising that issue, I think a lot of that as to whether or not it poses any legal issue is really going to turn on some benefits questions. So I just wanted to put that out there. Of course, when you're talking about incentives, there could be issues of discrimination. And in fact, the EEOC in its most recent guidance actually talked about incentives. And I think they use a de minimis standard if you're using those incentives. So, we didn't touch on that at all today in our presentation, but I saw a couple questions in there and just wanted to be sure to at least highlight that a little bit for purposes of our talk today.
Yeah, and for the purposes of a private act for public disclosure of private facts, an invasion of privacy claim, to speak more specifically to your question, First of all, you got to show that it's offensive. I don't know that being vaccinated necessarily constitutes as being an offensive thing. Some might consider that to be offensive. And then the fourth element of a cause of action there is that it's not of public concern. In the case that the question described was regarding, I believe it was getting grant funding, and so whether or not organizations are vaccinated or not, there could be an argument that that is an issue of public concern because we're in the midst of a pandemic. So there may be some defenses to that, but again, I think it's a question that's ripe for litigation. So.
Excellent. So we've hinted a lot on vaccinating questions. So let's address one on the accommodations on long COVID. And one of the questions is what if the brain fog now doesn't allow a person to do the job with any accommodation? What would, I guess, James, on your perspective from the employee side be, and Lakeisha on the management side?
And this is specifically about brain fog. And it's interesting because, we have had employees come to us who have said, look, I was terminated for, doing a bad job or something like that. But, I have this brain fog as a result of COVID, and shouldn't that be accommodated? And can I be discriminated against as a result of that? And I think, again, the lawyer question is maybe. I mean, we really haven't dealt with these situations where COVID has come up and it's been well litigated. I think we can probably, I would suggest, analogize those cases to other sort of mental impairments and determine whether or not the employee can be accommodated and is able to do the essential functions of the job given that disability. And so if I'm analyzing those cases, that's really where I'm going to come down on whether or not I file that charge or not, or file that lawsuit or not.
Yeah, I don't know if it, at least from an employer standpoint, it comes out any differently. I mean, at the end of the day, you still have to be able to perform the essential functions of the job. And it sounds like, James, from your perspective, you're right there. And I think that's what it comes down to. And, again, you still need to engage in that interactive process so you understand if, in fact, this brain fog is impacting the employee's ability to perform an essential function. And if, in fact, after going through that that interactive process, it's demonstrated that the employee cannot perform the essential function of the job and you cannot, in fact, accommodate them, then I think from our perspective, an employer would be well within their rights to move forward with terminating that employee. But I think at the end of the day, it's still an answer of it's going to depend on the job that the employee is performing, exactly what they're calling brain fog, how it impacts them, and, whatever factors are critical as a part of that interactive process.
All right. Well, I appreciate both of you. We have a ton more questions and we are out of time. So the PowerPoint will be emailed to all those who participated in today's seminar. We appreciate everyone taking their time out of their lunch hour to listen to these speakers present on this very timely topic. And we hope everyone has a great day.
Yvette, there was a request for the CLE number. Do you have that handy?
I don't. We'll have Angie send it around with the materials.
Perfect. All right. Thank you, everybody. Have a good day.
Thank you, everyone.
Great day.
Bye.
Bye.